Welcome to the My Citizen Agency channel. Preparing documents for repatriation is a process that requires precision and attention to detail. One of the most alarming situations is the loss or damage of documents confirming the grounds for repatriation. People often think if I don't have the originals, the process is impossible. But in most cases, this is not true. Today, we will discuss what to do if your repatriation documents are lost or damaged, what steps to take, and how to act competently so as not to jeopardize your application. For repatriation programs, the key documents are those confirming the applicant's family ties and national origin. It is on the basis of these documents that the entire chain of evidence is built, from the ancestor to the applicant. It is important to understand that it is not a single document that is checked, but the logic of generations. The consulate analyzes how consistently and documentarily the relationship between relatives is confirmed. Most often these are birth certificates, marriage certificates, archival references, documents on change of surname, civil status records, old-style military ID cards, archival extracts, house registers and extracts from them, metric records. Each of these documents can play a key role. For example, a marriage certificate explains a change of surname, an archival reference confirms information from a civil registry record, and a birth record links generations into a single line. The peculiarity of such documents is that many of them were issued decades ago. Paper deteriorates, stamps fade, pages are lost. Sometimes records are made by hand and become difficult to read over time. In addition, the documents often belong to relatives who have already passed away, and the originals may not be available. They may have been kept by distant relatives, lost during moves, or simply not passed down in the family. Therefore, when preparing for repatriation, it is important to assess in advance which documents are really necessary, which can be restored, and which will need to be confirmed through archival sources. First, do not panic. The absence of the original does not mean that it is impossible to confirm the right to repatriation. In most cases, the issue is resolved by restoring the record or searching for alternative sources. It is important to act consistently. Determine which document is missing. You need to understand whether it is a key document or an intermediate one. Sometimes it is not the main document of an ancestor that is lost, but a connecting one. For example, a grandmother's marriage certificate, which explains the change of surname and connects generations. Without such a document, the chain of kinship is formally broken, even if the other documents are available. Check the possibility of obtaining a duplicate certificate. Civil registry offices issue duplicates based on archival records. Even if the document was issued decades ago, the record may be stored in the state archive. A duplicate certificate has the same legal force as the original document. Send a request to the state or regional archive. If the record is old, especially older than 50-70 years, it is usually transferred to the archive. In this case, an archival certificate or an extract from the register is issued. Such documents are accepted when considering repatriation cases, if they are properly executed. It is important to note that an archival search may take time. Sometimes it is necessary to clarify the year, place of registration, or even variations in the spelling of the surname. Consider alternative evidence. If the record has not been preserved, indirect evidence may be available. Archival certificates, house registers, metric records, military documents, documents on the family's place of residence. In some cases, legal proceedings are used to establish kinship. The main task is to restore a continuous chain of generations. Repatriation authorities evaluate not a single document, but a body of evidence. If the logic of the family line is confirmed by documents and is consistent, the absence of the original does not become a critical obstacle. Check documents confirming territorial affiliation. In a number of repatriation programs, the place of residence of an ancestor during a certain historical period is important. The administrative affiliation of the settlement at the time of the event, birth, marriage, or residence, is significant. Therefore, the following may be required: archival references about the place of residence, extracts from house registers, registration documents, archival data on the affiliation of the settlement to a specific territory, historical references to border changes. The peculiarity is that borders and administrative units have changed. The same settlement could belong to different territories in different years. Therefore, it is important to confirm that during the relevant period, the ancestor lived in the jurisdiction that meets the program requirements. A damaged document almost always raises additional questions during verification. Repatriation cases are reviewed carefully, and any doubts about the authenticity or legibility of the document may lead to a request for additional confirmation. The damage may seem insignificant to the owner, but every detail matters in an official assessment. If the stamp is blurred, the signature is partially erased, individual lines are illegible, surnames or dates are illegible, part of the page is missing, the document is torn, faded, or laminated, there are traces of gluing or corrections, the consulate or authorized body has the right to declare the document invalid or request additional confirmation. Issues are particularly sensitive with old-style documents where information is entered by hand. Even minor damage can make it difficult to establish facts such as date of birth, place of registration, or information about relatives. In such a situation, the correct approach is not to try to explain the condition of the document verbally, but to obtain a duplicate certificate or an archive extract. An official duplicate is issued on the basis of the record and contains the same information as the original document. It is important to understand that for repatriation, a duplicate has the same legal force as the original. In some cases, it is even preferable, as it is issued on a modern form, is easy to read, and does not raise doubts during verification. It is worth emphasizing separately, you cannot try to restore the document yourself, glue pages, retouch stamps, laminate worn paper, or make corrections. Any traces of interference automatically intensify the verification process and may lead to additional requests. If the document is seriously damaged, it is strategically better to replace it with an official duplicate certificate before submission than to try to pass the verification with the problematic original. One of the most difficult situations is when archival data is completely or partially lost. In this case, the standard path of recovery through recertification becomes impossible, and more in-depth work is required. Archival losses are possible for various reasons: military action, destruction or damage to archival collections, liquidation of institutions, loss of metric books, administrative reforms and transfer of archives between regions, lack of systematic storage in earlier periods. Sometimes a record formally existed but was not actually preserved. In such cases, it is important not to stop at the first negative answer, but to develop an alternative strategy. In the absence of a direct record, the task is to reconstruct the evidentiary logic through a combination of sources. Repatriation authorities assess not only the existence of a specific document, but also the overall credibility of the chain of evidence presented. Each situation is unique. Sometimes comprehensive archival work is required in several regions or countries at once, especially if the family changed their place of residence or the borders of the territory changed. It is very important to assess the prospects before submitting an application. Repatriation programs involve strict verification, and if the evidence base is insufficient, this can lead to rejection. It is much safer to analyze the archival situation in advance and understand whether it is possible to reconstruct the line of documents or whether additional legal procedures will be required. The short answer is yes. It can, but it all depends on how you solve the problem. If the loss of a document is ignored, the chain of kinship remains incomplete, or unofficial evidence is presented, this increases the risk of rejection. Repatriation authorities evaluate the documentary basis, not the applicant's intentions. But if the documents are officially restored, the archival data is confirmed, and the logic of the family line is constructed consistently, the loss of the original itself is not a reason for a negative decision. It is important to understand that the decision is made based on the totality of the evidence. If the documents are in the process of being restored, in some cases it is reasonable to postpone the submission in order to present a complete set. This reduces the likelihood of additional requests and delays in consideration. In some situations, documents can be restored independently. For example, if a duplicate of a relatively recent certificate is required and the place of registration is known. In this case, the procedure is usually standard and does not cause any difficulties. But when it comes to documents from the 1930s, 1950s and earlier, archival records, name changes, moves between regions, or changes in administrative jurisdiction, the situation becomes much more complicated. Here, it is not just the submission of the request that is important, but the right search strategy. Mistakes at this stage can lead to wasted time, an incorrectly specified year, an inaccurate place of registration, or an incorrectly worded request often result in a negative response from the archive, even though the record actually exists. In such cases, specialists determine in which archive the record may be stored, take into account historical changes in borders and administrative units, form correct and legally accurate archival requests. Analyze alternative sources in the absence of a direct record. Check the continuity of the line of generations. Develop a legal strategy for preparing a package of documents. In addition, professional support allows you to assess the risks in advance. Is there enough evidence to submit, or is additional work required? This is especially important if the submission deadline is limited or the case is already under review. In such situations, every mistake can lead to delays in the process or additional requests. A well-designed strategy from the outset saves time and reduces the likelihood of rejection. The loss or damage of documents for repatriation is a difficult but solvable situation. It is important to understand that the decisive factor is not the availability of the old original as such, but the ability to document the right to apply. In most cases, documents can be restored, archival information can be found, and the chain of evidence can be rebuilt. The main thing is to act systematically, not to ignore gaps and not to postpone the resolution of the issue. Repatriation programs involve strict verification, but with the right approach, even complex archival situations can be resolved. Mistakes most often arise not from the absence of a document, but from the wrong strategy. If you are just planning to immigrate to the European Union, leave a request for a free consultation at the link in the description. We will study your situation, draw up your personal immigration plan, and prepare a complete set of documents for successfully obtaining citizenship in one of the European Union countries. Thank you for watching this video. If you are interested in this topic, subscribe to the channel and feel free to ask questions in the comments. We regularly publish program reviews, answer frequently asked questions, and share important news about immigration law and life in the EU. Your journey to Europe begins with the first step. My Citizen Agency is with you every step of the way.